But we want to note that the publication version is expected to publish on March 4th. Following that, we expect comments to be due on May 3rd. And we encourage folks to comment and to use the comment processes that are identified in the rule for how to comment. So any comments or questions that you raise that are raised on this call or via the chat function would not be considered for part of the public comment process. The last thing I wanted to note is some of the webinars that we have coming up. This webinar that we're giving today is designed to be an overview, but do note that there's going to be several webinars that we will have on the rule, including one on application programming interfaces in the NPRM. We'll have one as well on information blocking, so an entire webinar just on the information blocking provisions that we propose. And we'll also have a follow-on as well. We expect that there may be some questions, but given the amount of content that we expect to cover in this section, if we expect that there may not be time for all of the questions that come in which case the webinar that will be held on March 28th will provide an additional opportunity for stakeholders to ask us questions. And again, I will note that some of those questions we will not be able to answer depending upon whether they are related to interpretation or substance that's not included in the rule. Last, there are 4 task forces that we have started up with our Health Information Technology Advisory Committee that will take a look at some of the policies that we are contemplating for purposes of supporting our goals of patient access, health information exchange, and information blocking, as noted in the rule. To follow the Health Information Technology Advisory Committees and comment, which there's always an opportunity to comment during the public calls, please check out our website as well, and you can find not only more information on the task forces and the members of the HITAC committee, but you can also find additional information on when all of the task force meetings will be held. With that, we'll go to the next slide. All right, so now we have all of the disclaimers out of the way and kind of informational notes. I wanted to make sure that we start with an agenda. And as you can see here, there's a number of components that we plan to cover as part of this session. Keep in mind that the webinar is being recorded and will be posted on our website. So we just want to make sure folks are aware of that fact. So if you are for some reason not able to stay on the line for the entire call, you'll be able to catch this later on via the same website link that I noted, which is healthit.gov/NPRM. Also, my general disclaimer is that you'll notice that these slides are pretty substantive as we go through them, and that's on purpose. Our goal is for these to be resource slides, to highlight some of the provisions in the rule, but note that we know that it may not be as easy to follow, but that's okay. We hope that these are helpful for you on an ongoing basis. Next slide. So just a quick highlight. I won't spend too much time on this because I do want to make sure we get into the significant substance of the rule. But note here that we put together kind of a quick view of the provisions in Title IV that we intend to implement through this proposed rule. And that would cover everything from pediatrics to the conditions of certification and maintenance of certification and requirements that would be updated within our Health IT certification program. The definition of interoperability. Thinking about information blocking, we propose 7 categories of practices that would be considered reasonable and necessary when looking at a claim of information blocking. We also include a request for information, which I'll talk about later, regarding exchange with registries, which is noted in Section 4005, and 4006, which is patient access. Throughout our entire rule, I think one of the themes that you'll see is that there is a mention and a commitment to ensuring that patient access is achieved through means that work for the patient and the providers that serve them. So from information blocking to the conditions that we've included, you'll see that resonate across the criteria and then the policies in section that cover Section 4004. Next slide. When we think about the goals of our rulemaking, one of those is around supporting the executive orders that have been released as well. And those are about promoting healthcare choice and competition across the United States. And through our rule, we support the innovation that can happen through things such as application programming interfaces being available without special effort and allowing patients to have ready access to their information at no cost. In addition, we've also thought about activities that we could we could further through the proposed rule that would support reducing regulations. One of those is around removing the 2014 edition from the Code of Federal Regulations. And I note 2014 because the 2015 edition is the latest edition that we released and what is referenced by many of the CMS programs. The 2014 edition is an older edition, and we think removing that makes sense as well. And moving to the next slide, we talk a little bit about our purpose. And what is our purpose through the rule? First and foremost, to implement Title IV of the Cures Act and to support innovation and competition. I noted that as well on the previous slide, but thinking through giving patients and healthcare providers safe and secure access to their health information. That's through new tools, that's through the criteria that we would support by updating the Health IT certification program. And that's also by supporting more choice in terms of care and treatment that would be available by the patient when they're thinking about care, helping them to move their information as well. We also think about reducing burden and how to advance interoperability. And our United States Core Data for Interoperability, which we affectionately call the USCDI, is an updated, more expansive standard to enable more data to move through interoperable means. We also include new API requirements, application programming interfaces, and an electronic health information export capability that would give providers as well as patients more access to their health information, requiring certified health IT developers to support the switching of providers, so where providers are moving from one developer to another, ensuring that that can happen in a more smooth way than what we've heard in the past, and supporting the ability of patients to pull down all of their electronic health information out of such systems. And then last, I noted the importance of patient access, and I think as we go through these slides, you'll see that come across as well. Next slide. So now I want to turn it over to my colleague, Mike Lipinski, for one who is the main architect of the rule. He is our lead rule writer and heads up our Division of Regulatory Affairs, to talk a little bit about the deregulation actions as well as some of the updates we would include in the certification program. Mike?
Thanks, Elise. I want to make sure everybody can hear me, so let's do a sound check first on that. Can everybody hear me? That's great. I saw some yeses on the web chat, so I appreciate that. Good afternoon and good morning still to our folks joining us from the West Coast. Appreciate you spending the afternoon with us to learn a little more about our rulemaking. I do want to make clear to folks that this will be available, if you didn't catch it in the beginning, this presentation, the slide deck will be available online, and we are recording it, and that we will be doing a couple more specific presentations later, one on API and one on information blocking. And then at the end, we'll have another overview of this, very short overview of the rule with a focus mainly on questions and answers from you. So you'll have had an opportunity to look at the rule in depth and talk to us and ask some questions. Okay, so let's dig in today. As Elise mentioned, there's a lot of text on some of these slides, and they're really for background. And I'm going to point out this is the first time we're talking about the deregulatory actions that are in this proposed rule. In prior presentations, we hadn't focused on this yet. And there's some good, again, on our, I'll pitch the website, healthit.gov/NPRM. We have a fact sheet on our deregulatory actions you can find there as well. So we focused on 6 proposed deregulatory actions. This is coming out of the executive orders from the president on trying to reduce regulatory burden, looking at previous regulations and seeing where there's an opportunity to do such. And I would just say that ONC has a history of this. We laid this out in the rule. We've done it starting with, it used to be you have to have all certified health IT for a setting, and then we went to the base EHR definition. We permitted gap certification. We removed some criteria from the base EHR in the past, image results, things like that. We did release 2 of the 2014 edition to give some more flexibility to developers. So to us, this is just continuing on a path that we've always been on, which was trying to be responsive to stakeholders, and go with the least burden possible, yet achieving the goals of the program. So I'm going to go into each of these 6, not too deep, but you'll have the slides, and then obviously you can go to the rule where we talk even more about it. So let's go to the next slide. We removed randomized surveillance requirements. If you're familiar with our program at all, we actually did this almost a year and a half ago via enforcement discretion. And now we're following through by actually removing the regulatory provision. And really what this does is allow the certification bodies to be more responsive to complaints. So we focus on reactive surveillance. We had heard from stakeholders that sometimes, randomized surveillance was not necessarily beneficial because it took up times of the provider. There was no problem being reported. While we still think it's a good approach to ensuring, quality of the program, integrity of the program, and to that point, we allow the certification bodies to still do it. We're just not requiring a 2% threshold. So that's what this particular proposed deregulatory action is about. We're also going to remove the 2014 edition. We've done that in the past with prior edition, the 2011 edition, if you're familiar. We lay out many of our reasons. Obviously, two of the biggest are this, the 2014 edition. It was from essentially rulemaking started in 2011. So 8-year-old standards and tech requirements. We've obviously went to the 2015 edition, and in this rule proposing some more enhanced health IT functionality that will improve interoperability. So let's move to the next slide. Talk about a couple more of these deregulatory actions. So this is more of an administrative one about the ONCAA. So we thought that there was a lot of duplication in the oversight there. So we're proposing to remove the ONCAA. What I do want to emphasize, however, is a certification body still has to be accredited. And what we see this as is giving some flexibility to the market there, so they can be accredited by anybody who accredits to the standards that we require for certification, which are 17065 and related to health IT requirements. So they're still going to have to be accredited. They're still going to have to do everything the certification bodies that they had to do before in terms of being responsive to oversight. We just saw this as a duplication in the program. So then the next one, and I'll talk a little more about this one later, but when you see what we're doing with the whole 2015 edition, and this is removal of certain 2015 edition criteria. So you see them there in the corner. When we looked at some of the criteria, we looked at them from the perspective of and this goes back to our main purpose, right? And you're going to see this theme through everything I talk about that Elise talked about, what we're trying to achieve with this rule. So we're focusing on interoperability, also burden reduction, whether it's through the program or through the tech that will reduce burden for providers and patients in getting access and using EHI. So here, a lot of these criteria that are identified are just about recording the information. There's no standards associated with them. Really, it's been the same criteria since the 2011 edition. We're just saying, does this product have this functionality? We think that's, at this point, since it's been in the program since like the 2011 edition, we think the functionality is ubiquitous. We don't think health IT developers would ever remove such functionality because providers need it. And then again, it doesn't associate anymore with what is now the promoting interoperability's objectives and measures from a recording perspective. Now, be clear, a lot of these, your meds, your med allergies, we still require through and we're going to talk about what's going to become the US CDI if the proposals are finalized, that certain data will have to be standardized and be available for access and exchange. So again, as much as clarity as I can about this is really about just recording functionality, not what data and how in the format of that data that's made available for access and exchange. Okay, let's move on to the next slide. So this one is another one where we tried to look at, see if there's any duplication. This is number 5 I'm talking about. I think with the info blocking provisions, we feel that some of these particular disclosure requirements aren't necessary between the new conditions of certification, again, in the info blocking provisions. And you can read more about that in the rule. And then the last one, we tried to be a little bit innovative. I'm not sure if you know the history behind ONC and FDA, but we've tried to work closely together, particularly ever since what's affectionately known as FDASIA, the law that's referenced here on your slide, where we were supposed to look at creating a regulatory framework that reduced essentially duplication but yet still promoted safety and innovation. And so here we're if you're familiar with FDA's software pre-certification pilot program, we're trying to see, and they're looking more at not the product but the developer of the product. So we were trying to see first, if a developer went through there and then had products in our program, could we give some type of recognition to that for our program so there wasn't a duplication again of regulation. And then two, I want you to take a look at it where I'm talking about the the more innovative piece, with our new authority for the program under the Cures Act, we're requesting comment on whether we should take maybe a similar approach in our program, and for maybe certain criteria that, or limited to only certain criteria that are interoperability based. Again, if we were to do anything in that specific space, we'd be looking at a future rulemaking to do that. But so now we're just kind of requesting comment on that. Okay, let's move on to the next slide. All right, so let's jump into the 2015 edition. And so this is another one where we tried to, again, reduce burden and focus on interoperability. And what I mean by that is we weren't going to ask for a wholesale change of the industry to a new edition, that we wanted to recognize what they had put in place from an interoperability perspective and focus on what key components of interoperability we could improve through this rule and align with what we were asked to do via Congress and the 21st Century Cures Act. All right, so let's move on, next slide. I just want to make you aware of this resource. We put this together a couple years ago, maybe now, year and a half. It's on our website. There's the link for it. And what it does is it shows you, it kind of takes what's in reg speak and talks about each of our categories of criteria and speaks to them in those categories you see on there and the functionality we're hoping to instill into health IT that providers and users are, providers that adopt and users are using. And it talks a little bit about what each of those criteria would enable or support. So if you want to learn more about the program and the functionalities we're trying to ensure that health IT have through a certification program, please take a look at this, this resource. Let's move to the next slide. Okay, so this is like a one slide trying to sum up everything we're doing with the 2015 edition for you. So I already talked a little bit about the removing of criteria, and that's what you see at the top there. But there's also this updating where we're kind of removing and replacing. So while we're removing the criteria, we're replacing it with better functionality or functionality that aligns with other department proposals or requirements, or generally will improve interoperability, patient access, and so forth. So I'll talk a little bit, actually I'll talk about almost all these criteria here, but I wanted to have it for you in one place. What's different than a prior presentation that we gave, I wanted to point out on the revised criteria here. So to be fully open about everything, there are a couple proposals in our rule that get to improving interoperability by applying our proposals for US CDI and updating the code sets, the vocab code sets. So like, SNOMED, RX norm, to the newer, setting the baseline at the newest version, because the 2015 edition was released back in October 2015, and we're talking by the time we have a final rule here, almost 4 years or more, right? So we want to set the baseline higher here. So what we're talking about here is any CCDA-based criteria. We're proposing updates for those to align with the new US CDI, as well with a companion guide that was issued by HL7 to improve the recording of the data within the CCDA. And then last, again, like I was talking about, the minimum standard code sets, where any criteria, so that's even some of the recording criteria would be affected by that, like family health history, even. So that's the full scope of the proposal there. And then we have some new ones, which are really, and I'll talk about these two. One is about, again, consent management and helping move, moving information when there's sensitive, moving EHI when there's still sensitive information in a patient's record. And then the other two are about just a transparency criteria, and they came out of a prior Health IT Standards Committee recommendations. And so I'll talk about those two. So why don't we move into that and start talking about some of these criteria. First up, though, base EHR definition, and we want to give you that as well. One slide here that lays out everything we're doing to changing the base EHR definition. I kind of alluded to this in some of the other slides about what we're removing, what we were replacing. So this is how it changes the base EHR definition, which is for those of you who either support or participate in a promoting interoperability program or alternative payment model that cites to the certified EHR technology definition. This is the foundation of that definition. So that's why this is so relevant. And on the left side, it's really the statutory capabilities that were first highlighted that Congress thought all health IT should have and be able to provide to healthcare providers. And so we aligned that with the criteria. So that was the HITECH Act, and it's found in the Public Health Service Act now. Okay, let's move on now. Talk about the criteria. So the first up is the data, right? So we've now proposed what was before the Common Clinical Data Set as a standard. And I think we're going to reach out, and I'm going to show you the whole, and we have on our website, like I was referring to before, the healthit.gov NPRM, and show you what we think is a great resource for you about this. So that's the website. You'll see all these fact sheets there, and we're going to go to the US CDI one, which is right dab in the middle there. There we go. So here it is, everything, which is the CCDS, and then the new criteria highlighted for, the new data elements and for you in classes. So as you can see, clinical notes is now proposed to be a part of the US CDI, and there's, I believe, 8 there, right? 8 clinical notes. We're also adding address and phone number, and then some provenance related to the author, timestamp, and the organization. And then PEDS, it's new as in required. It was an optional part of the CCDS, and so we're taking the next step. We think there's a lot of reasons for this data to be available from both a longitudinal perspective in treating patients, and but we obviously request comment on all this as well. All right, so maybe let's go back to the slide. Just want to give you a sense of what that looks like, that some of those resources we've been talking about available for you on our website. And we can move on to the next slide. As we do move on that, just one quick thing I'll mention about the prior slide. Since it's a standard now, there'll be a process to updating that standard. We're requesting comment on that, and our Office of Technology will be leading that process as it goes from finalizing version 1, which is draft now, and then moving to a version 2 and so forth. So EHI export. Okay, so this is one of those criteria where we were trying to address, stakeholder feedback, in some respects, quote unquote, a market failure. So we have heard from so many providers, it's so hard to switch systems. We think this is one step in that direction to do it. We also think this is going to help get, per the Cures Act, patients all their data, and all their EHI at least, as we try to move to get it all coming out in through the API. So what this is going to entail is the developer providing their data dictionary. So, and they have to make this publicly available, as you see on the slide, via hyperlink. And that way, you'll know the format of how that data is kept. And so a third-party developer could help build to it and help pull that data out for a provider or even for a patient. And so that's one thing that could come of this. But clearly, the main goal here is to help these 2 use cases. And so in that regard, we're going to require, or proposing to require, as you see there, that this functionality from the effective date of the rule be rolled out within 24 months. So that means, and it's also, as you saw, part of the base EHR definition. So all developers, all providers who have to meet the CERT definition will have that functionality as well. And here's where, you know, you start seeing all the various policies interrelate. In info blocking, we have a proposal that says once that, you know, that agreement between the developer and the provider to buy or license certified health IT, and it includes this functionality, they can't then charge for the use of the functionality. So that's to address, again, some of the concerns we've heard about, you know, quote unquote, holding the data hostage. All right, let's move on. Next slide. API, another proposal here, hoping to get the data out, doing it in a standardized way. So we had an API previously in the 2015 edition, and we're going to propose to replace that particular API criterion with this one. This one has obviously the FHIR. I think you've heard that we're proposing to the standard. We're taking comment. We started with the base FHIR 2 version. FHIR 4 came out recently, just a little over a month ago. So we have comment in there, request for comment in there, whether we should, you know, what are the various options, how we should propose for certifying, or excuse me, for eventually requiring health IT to be certified to this criterion. So whether it's FHIR 2, whether it's FHIR 4, whether there's a glide path, whether it's even FHIR 3, we asked for comment on that, or one or the other. So we've kind of left open a lot of options that, you know, we're looking for stakeholder feedback as to what will best suit the industry and those using this tech. So we're really looking forward to comment on that. Again, looking at what we think can be enabled through the API, and that's the ability to pull out data for a single patient and then for multiple patients. And again, I'll point you to the website where we have more in-depth fact sheets even about the API criterion. And we'll talk a little bit about the condition of certification when we get to those and how that relates to this criterion. This is another one you'll see when we get there about how that 2-year period I talked about, that again, if they're certified to API, they have up to 2 years to roll that out, developers that is, to their customers. And it's also, again, part of the base HR definition. Let's move on. So a couple other criteria that we're proposing changes to. So this one was, I alluded to way in the beginning about alignment with other requirements within the department. So here, this is a proposal to align with the Part D e-prescribing requirement and standard. So we have that here. This would be, you know, become the baseline, same transaction standards plus the same requirements we had from before. Same transaction standards, I should say, that is required on Part D, same other requirements that we already require in the e-prescribing criterion. So important to make clarity about that. And this would be also, again, a replacement one. And then CQMs. So here, again, trying to be responsive to stakeholders, many we found were getting certified to what was an optional requirement with the current C3 criterion, which was to be able to support reporting to CMS using their QRDA IG. What we found is, you know, maybe, you know, what we thought the use of the other HL7 QRDA would serve other purposes, but what we found is that focus has been on the CMS QRDA, and so we think this is a potential way to reduce burden by focusing only on that IG for certification. Again, welcoming comments on this. Can we move then to the next slide? All right. So these are those criteria we're talking about that are, I want to emphasize, attestation criteria. So what are we talking about here? We're asking developers, you know, do you have this functionality in your certified health IT, either directly or through a third party? And so do you encrypt authentication credentials, essentially passwords, right? Or do you not do it, right? You have to attest one way or another. And then multi-factor. Do you use multi-factor authentication? What do you use it for? So that's another, you know, we're asking, you know, like what information would be helpful from a transparency perspective to users and purchasers of certified health IT. So is it, you know, what type of multi-factor authentication they use and for what purpose, or, you know, is that even valuable to know or not? So this is a proposal, and again, it's whether they do it or not. That's all they have to do to meet the criterion, the developers, that is. But I would point you to the request for comment from stakeholders about what would be of value from a transparency perspective related, particularly to multi-factor authentication. And we lay out a lot of data why both of these things are, important, from protecting the data and so forth, and the costs associated with just simply having to reset your password all the time. From a provider perspective, that is. Okay, let's move to the next slide. All right, data segmentation for privacy and consent management criteria. So here we had previously the consolidated CDA-based criteria for DS4P, as is affectionately known, but we only focused on document level tagging. So with this criteria that we're proposing, we would replace the prior criteria with new ones that we think will better support the ability to segment the data and then move the data and make it available. So that's at both the section level and data level, element level. And then also trying to be very proactive in terms of using APIs for data, getting it out, exchanging it, making it accessible. We looked at what was out there, and it's consent to share, which is another way to do this through a FHIR implementation. I will say and point you to, I don't want to spend too much time on this, but in the rule we talk about what versions, the version I believe that's aligned with is really more with FHIR 3. However, I believe there's work being done to move that implementation to align with FHIR 4 as well. So again, please look at our write-up on that one in the rule, and we really would appreciate comments on that as to what's the best direction there to support this use case. Which obviously supports multiple practice and care settings. Okay, let's move to the next slide. All right, I'm going to talk about a new requirement that Congress put forth in the Cures Act to regulate not just the health IT, but the developers, and particularly like the developer behaviors. So let's jump right in here. Next up. All right, so here's all 7 per the statute. As you can see, number 7 there is in a offset color, blue, because we're not in this rulemaking proposing to implement it. We're waiting until after we have criteria established for the HIO reporting program, and that's on a separate track where we have already done a request for comment and got stakeholder feedback. All right, moving to the next slide. So this is just a straightforward one where, beyond the whole info blocking provisions that I'm going to turn it back to Elise to talk about, here developers also have to attest that they're not info blocking, so then they can be held to a potential false attestation. All right, moving on to the next slide. So besides info blocking, Congress said that that the Secretary should also look for developers to provide additional assurances that the developer was not taking any type of action that would inhibit the appropriate exchange, access, and use of HI. So we've proposed a few on that, and actually request some comment related to TEFCA, Trusted Exchange Framework and Common Agreement. Clearly, we're asking to say that their product, once implemented, can fully do all the criteria that they were certified to. So this is where a backstop to just the testing, which doesn't necessarily test every single capability. And this is when, and we'll talk about another backstop to that, which is real world testing, another condition of certification. So you have that. You have that, as I talked to you about before, and this is again a connection and alignment of that EHI export. So any health IT developer that produces and electronically manages EHI, they're going to have to get certified to that criterion we talked about, roll that out, and that will help make all the patient's data available that's in that provider system, and it'll help any provider who may choose to switch systems. Records, we want to make sure that the records are available to check to make sure that for compliance purposes, and then I alluded to whether there are certain developers based on the functionality and what they support for providers and users, should they be actually required as a condition of certification to participate in the trusted exchange and adhere to the common agreement. So let's move to the next slide. Looking for your feedback on those though. So communication slide. This is one where Congress specifically specified that developers should not prohibit or restrict any communication, and they set out the topics, right? Usability, interoperability, security, you see them all on the screen there. And we pretty much have followed this. It's a very broad restriction and prohibition. So we've tried to follow that. Where we've made some exceptions is where we've allowed the developer to put some restrictions in place when it involves certain specific situations, such as if it's a employee of the developer. That's one example. Or if it's it's still in a beta, the health IT testing. So, and you can look at some of the other ones there. What I want to highlight, this IP, as far as IP goes, intellectual property rights. What we've said there is that you know, and they can put certain restrictions on as long as they meet other conditions. But when it comes to one particular type of IP, screenshots that is, we lay out a proposal where we believe that exchanging screenshots is fair use of the IP as long as certain conditions are met. And those conditions are that they're not changing the screenshot in any way, the person who's making the information available, that they're not including any PHI in it, and that they're not exposing any third party's IP rights. And when it comes to that, the EHR developer actually has some responsibilities to try to secure the release of those third party IP rights. So, and very importantly, you'll see at the bottom of the screen, we're proposing that within 2 years of an effective date, any contract that has anything in it that contravenes these restrictions against prohibiting this information, it has to be out of it has to be out of that contract or be in violation of this condition of certification. And so this is really like, you know, in some, the gag clauses. Congress spent a lot of time about this. They had a lot of feedback from, you know, hearings, and pretty much everyone, even developers universally, said that such, you know, gag clauses shouldn't be in contracts. So through our certification program, we're going to try to implement that and enforce that. All right, moving on. The API condition. So this ties to that criterion I talked about. So there are then essentially three sets of, we've kind of bucketed them in three sets of conditions that align with the certification to that criterion, or any really API criterion. It's not just the one I talked about. So, you know, there's requirements about transparency, about what fees can be charged and what fees cannot be charged, and that aligns back to info blocking. And then some other requirements about how they make their information, their IP information available to promote an open competitive marketplace. And there'll be a presentation, as we talked about in the beginning, just on API. So if you're really interested in that, I recommend attending that. I think it's the 14th, but please don't quote me on that. We'll pass out the information, I think, to all attendees about their future webinars. And also there are fact sheets on API, as I mentioned earlier, on our website. Let's move, in the interest of time, I'm taking a look at the clock, on to the next condition of certification, which will be our real world. Oh, so that's just some more specifics about that. So I'll let you read that at your leisure. Real world testing. So this is about interoperability in the field, right? Like once it's been installed, implemented, the health IT, been kind of alluding to this at various points throughout my discussion of our proposals. So here we tried again, you know, a bit of a balancing the burden, but advancing interoperability. So we're focusing on real world testing related to those health IT that are certified to criteria that we think support interoperability and data exchange. Those are identified on the screen there. And those are like those categories I talked about way back in the beginning, about 20. So like C1 through C3, that's clinical quality measures. The 315 is the care coordination. 315B, that is the care coordination criteria. And F is public health, and so on. So we're asking, in that burden balancing piece, we're asking developers to give us a plan, and there are definitely certain criteria and conditions as to what has to be in that plan, and into the setting in which they're going to market and make that health IT available, but how they would go about interoperability testing their health IT, and then those results have to be submitted, and all that is going to be publicly available on our websites. And last, something that we're really excited about, it's called the Standards Version Advancement Process. We can go on the next slide. I think we have a slide just about that, and there's a fact sheet. Okay, so what this is using the real-world testing requirement, it allows, as the national coordinator, so say we adopt a Fire, a version of Fire, and then Fire 4, let's say, and then version 4.1 comes out. So the national coordinator could go through a process we're proposing to identify that as a newer version of the standard acceptable for the program. And so then developers, once they meet certain requirements about notification and so forth, they can update their health IT to that. They would have to then real-world test the health IT to it, but then once that's all happens as part of real-world testing, they would be subject to being their product conforming to the new version. So one, it's a voluntary approach to keep us moving, keep interoperability moving, but it also tries to provide assurances to those who purchase the health IT and use it that under the program it can actually do this newer version. It's been real-world tested to it. There's been attestation by the developer that they can do it and so forth. All right, moving on. I'm going to try to go through the next parts. So that's the attestation I was talking to you about, and then false attestation. There's authority for OIG in the Cures Act if there's any indication of false attestation by a developer to prosecute that, investigate and prosecute that. We have a whole process laid out how to make this a least burdensome process, a web-based approach to it for developers to attest. All right, next slide. So enforcement, how are we going to go about enforcing these conditions? Next slide. So here's a quick overview. There's really just two key things to take from this. We're using a process already in reg. So it's the process we set out through the Enhanced Oversight and Accountability Rule, which allowed for, gave us a regulatory framework for ONC direct review of health IT. So we're going to use that for the conditions of certification, enforcement of them, and compliance. As you see on the screen, we're proposing that ONC is best situated to enforce compliance with these conditions, particularly related to some of their complexity and how they focus on behavioral actions by a developer, and not just the health IT itself, which are where certification bodies are better situated. And also, we're going to be able to coordinate with OIG, particularly when it comes to information blocking in terms of our investigations, or even defer to them. Those are proposals we have. So we're going to move to the next slide. I'm not going to, again, spend too much time on it, other than to point out on step 6, a distinction from prior EOA approach to certified health IT. Here we're proposing the developer gets through the whole process, and we're going to focus on corrective action, but if they get through the whole process and they just don't want to address whatever it is, we're proposing they can be banned from the program. I think Congress obviously thought so much about this and about these particular behaviors and so forth that they put it in statute and wanted it part of the program. We feel that if developers were to violate them, an appropriate recourse is a certification ban. So the next slides I'm going to just skim through real quick because they're really just laying out all the processes. So we can just move through to the next slide after that again, and then to the next slide. So this is just one real quick slide. This is really more geared towards developers and folks that are in the weeds with the certification program. So what we're just laying out here is some of the technical changes, I'll call them, to the program. So this is really what the certification and testing labs have to do. Things that we think are going to improve the efficiency of the program, effectiveness of the program. So I just want to have that available for you on a slide as well. I talked to some of them about the ONCAA being eliminated, so the flexibility that could provide. and so forth, like with the randomized surveillance. All right, let's move to the next slide. I think at this point, I'm going to be turning it back to Elise to talk to you about information blocking. Elise, back to you.
Thank you, Mike. Thank you. So we have about 15 minutes left. So as I indicated, we likely will not have an opportunity for questions on this call, given the breadth and the amount of information that we're going through. But we are going to have a subsequent series of webinars. One is on application programming interfaces, and just to clarify, that will be on March 13th. We'll have an information blocking webinar on March 19th. And we will have an additional overview and Q&A session on March 28th. And again, you know, we'll answer the questions we can, but some, just keep in mind, we will not be able to answer where it involves interpretation or information that's not in the rule. So next slide. So we're going to talk a little bit about information blocking, but again, there's going to be an entire webinar on this. So I want to provide some high-level things for folks to be aware of. So first, keep in mind that when Congress laid out the information blocking section 4004 of the 21st Century Cures Act, the goal was for ONC to think through the exceptions that should exist when it comes to information blocking. So Congress lays out the actors, which are healthcare providers, health IT developers of certified health IT, health information exchanges, health information networks. Those are the four categories of actors that are regulated by the information blocking provision as per Congress. Congress also lays out a definition for those actors. So there are two definitions, one that applies for providers and one that applies for the other three actors. And all of this is kind of discussed in the rule. But this is important to keep in mind because the penalties are also different depending upon which actor is at issue. If you are a healthcare provider, not only is your definition of information blocking slightly different, but it also means that the types of penalties are different. If you're a healthcare provider, you are subject to appropriate disincentives as determined by the Secretary. And that's something that ONC as well as all of HHS is thinking through, and we do welcome comment on that as well and what that might look like. For the other three, developers of certified health IT, health information exchanges, health information networks, the penalties are up to $1 million in fines per violation. And that would be determined by the Office of the Inspector General. In fact, the Office of the Inspector General is the lead enforcer for Section 4004. So when it comes to potentially a complaint, for example, that comes in regarding information blocking, it would be the Office of the Inspector General that would review that and determine whether information blocking has occurred. One of the things that OIG can consider is whether there are reasonable and necessary activities that do not constitute information blocking, whether the actor's activities fall into those reasonable and necessary activities. And that's what ONC has laid out. ONC has laid out those activities, and there are 7 of them that we identify. In order for a violation of an actor to fall into one of those exceptions, there are a series of subcomponents that anyone reviewing the rule should take a look at. It's not whether you just fall into the high-level look at the exception, but whether the subcategories, the subcomponents are met as well. For any particular violation, an actor could claim, for example, one or more exception in order for the penalties not to apply. Next slide. So what is information blocking? And we have kind of generally, you can take a look here at the definition, definitional construct, and it's pretty much a practice that is likely to interfere with, prevent, or materially discourage access, exchange, or use of electronic health information. One of the key words I want to note here is likely, right? The goal and the presumption that Congress has laid out is that information is moving for the benefit of the patient and the providers they serve. So where information is not moving, then it has to be because of the 7 exceptions. And what OIG, Office of Inspector General, would look at is whether the action is likely to interfere, not just whether it did, but whether it is likely to interfere. Next slide. Another important concept to note is the definition of electronic health information. So when determining whether information blocking has happened, the set of information that is required to move would be the electronic health information. And if that electronic health information does not move, that's where information blocking comes into play. And some of the things to look at as part of that definition is, one, it has to be transmitted by or maintained in electronic media. It has to identify an individual, or there has to be a reasonable basis to believe that the information can be used to identify the individual. In addition, when thinking about the types of information, past, present, and future health or condition of an individual, the provision of healthcare to an individual, as well as the past, present, and future payment for the provision of healthcare to an individual. Those are the components that we think of for purposes of electronic health information. And as with everything else in the rule, we welcome comment on this. As we were developing this rule and bringing to life the components that Dr. Rucker wanted to see to support the movement and access of information, to support such things as APIs without special effort, and general importance of patient access and exchange, one of the things that we thought about is really this definition and what it should cover. A couple of other things to note here is that the information is not limited to information that is created or received by a healthcare provider. And in addition, de-identified information would not fit under this definition as well. Next slide. Price information. We've included a request for information on this category of information. We want to learn a little bit more about what are the parameters and implications that might apply when including information, pricing information within the scope of the definition of electronic health information. In addition, the department has noted that there is really an impact on the provision of healthcare across the care continuum when price information is not moving, or where there are concerns about access to such information. And for that reason, not only does ONC request information as it relates to information blocking, but the overall department seeks comment on a number of issues related to price information, price transparency, including technical, operational, legal, cultural, environmental, and other challenges that might exist. So we encourage comments on that as well. Next slide. So we're going to briefly go through the exceptions, very briefly, because there will be an entire webinar just on this section. I want to highlight a couple of things across the exceptions. There are exceptions on preventing harm, on protecting the privacy of electronic health information, and on promoting the security of electronic health information. Just to note, in these as well as all of the exceptions, you note that there's a couple of things we're thinking about. We recognize that the movement of information is the primary goal, but there could be situations where moving the information could actually result in harm, or where there are security concerns or privacy concerns that might exist. So we want to make sure that there are allowances for those realities to be considered. But the goal is not to allow for information to be prohibited by using these exceptions as proffers. If these exceptions are being used or such claims are being made, we need to make sure that they are, one, reasonable, and two, that they are fairly applied. And fairly really is a term that you'll see not using those words exactly, but using things such as reasonable and non-discriminatory. Those are some of the words we use throughout the statute. I'm sorry, throughout the regulation. So just going to the next slide. Going to the next slide. The privacy exception in particular, I wanted to spend just a second on, because I wanted to note that there are 4 discrete sub-exceptions that exist under the exception Excel. And one of them are to recognize that there may be some pre-existing laws that have to be taken into consideration, whether those are state laws or HIPAA, for example, and that also that the practices that the actor uses are respectful and giving effect to the individual privacy preferences as well. Next slide. The security of electronic health information is similarly looks at kind of some of those elements of non-discriminatory behavior and thinks through, if the exception is being requested, is the exception or is the practice that's being done tailored to specific security risks? And is it consistent across those who it is applied to? Next slide. Recovery of costs reasonably incurred. This in particular lays out some areas where costs can be where costs can apply to an action related to the movement of information. Again, the goal here is not to support an environment where costs are being used as a means to information block. Rather, where costs are being applied, they have to be on the basis of objective and verifiable criteria, and uniformly applied to all similarly situated persons and requests. And I highlight that in particular because, for example, it means not necessarily applying the same prices or price terms to everyone, but where price differences exist or price terms are different, that it is applied the same way to similarly situated persons. So if you're applying different prices simply because someone is a competitor of yours, that would be a factor that OIG would consider in whether information blocking truly has occurred. Another way to say that is where there are price differences, they have to be based on actual differences that exist between amongst the requesters. Next slide. Okay, in terms of infeasibility, infeasibility really looks at whether the decline for the movement of information, the decline to provide access, exchange, or use of EHI is based upon a request that is not possible given the circumstances of the individual actor. So for example, if you're a provider and a specific interface would need to be created for you to move the information, that would be a consideration in whether information blocking has existed. But even under this exception, we know that reasonable alternative means of accessing the EHI would have to be provided. And even responding to the request that you receive is part of the examination under this exception. Next slide. On the next one, we talk about reasonable and non-discriminatory terms. And this is really about, we understand that there can be some technical elements that an actor may have that they are using for purposes of moving EHI. And where that exists, certain licenses may exist. We have heard situations where licenses are used as a means to information block. And what we say here is where such licenses exist, they should be under reasonable and non-discriminatory terms. We would also look, or OIG rather, would look at a number of different components. And in addition, you see that phrase again, objective and verifiable criteria that are uniformly applied across those requesters. Next slide. And then the last exception relates to health information performance. We understand that systems sometimes have to be taken down to address a number of issues, whether it's maintenance that needs to occur now or later. But in those situations, we note that there is an exception for that. But one thing that to note here is that there has to be an agreement regarding the unavailability of health IT. And again, that should be applied in a consistent and non-discriminatory manner. So given that information blocking is going to be discussed further in a subsequent webinar, I'm going to jump to a couple of other areas, and we are running out of time. So I'm just going to note here, I would like folks to take an opportunity, if they're interested, to look at some of the slides we have around pediatric care and practice settings. What we've noted here are 10 recommendations, as well as several updates to the certification criteria to support pediatric care and practice settings. And these are things we think that those who operate in this sphere, pediatric care, would be able to consider and work with developers to have for purposes of supporting pediatric patients. We look forward to comments on whether we've hit the right notes on this. This has involved stakeholder engagement, including our work with ARC as well as CMS on things such as the children's EHR format. We also include a number of requests for information across the rule. Some are related to opioid use disorder prevention and treatment RFI, seeking information on how health IT can better help the strategies related to addressing opioid abuse. Next slide. Similarly, on patient matching, GAO recently released their report in January 2019, just now, pretty much, around patient matching in response to Section 4007. And we seek additional information on opportunities to lead or contribute to coordinating efforts around patient matching. And then also on registries. How can registries, for example, exist in an interoperable and bidirectional exchange environment, including ways that a standardized, standards-based API can assist in the movement of information between a provider and a registry. And then also here, we note that there are implementation milestones that we are aiming towards as part of our rule development. In closing, I would note that, we spent a lot of time hearing from stakeholders, and Dr. Rucker spent a lot of time hearing from stakeholders about their concerns and what they have seen across the landscape and impediments to care continuum exchange, access, and use. Our goal through this rule was really to lay out what we think would be helpful to the community, and most importantly, to implement what Congress has asked us to do around the access, exchange, and use of electronic health information. The comment period is expected to open on March 4th and close on May 3rd, but I would encourage folks to take a look at the Federal Register website for that information. There'll be follow-on webinars that specifically focus on specific areas. And I just want to give a huge thanks on behalf of Dr. Rucker to the ONC team for their development and work around this rule, and to the stakeholders for their engagement throughout all of the years with ONC, and hopefully upcoming in terms of our development of the final rule based upon the comments we received. Thank you again for joining us, and we would welcome your participation in future webinars and for your engagement on an ongoing basis related to supporting the access, exchange, and use of health information, of electronic health information. Thank you again for joining us.